This is Barry Zelma speaking for Zelma on Insurance on YouTube. I am an attorney retired from the practice of law and spend my time now as an insurance claims consultant, insurance claims expert witness and bad faith expert witness, and as an author and producer of these videos. Today I would like to talk about the claims commandments. Moses, 3,000 years ago, came down from Mount Sinai with the help of the Almighty with 10 commandments for the operation of the community. I have no direct communications with the Almighty. I am not as succinct as he, and therefore I have created 15 claims commandments, about which we will deal today. The first is thou shalt confirm coverage. When I was a young adjuster, I worked for the Fireman's Fund Insurance Company. Occasionally, confused insureds and brokers would report to Fireman's Fund a claim meant for Fireman's Insurance of Newark. The claim would often be adjusted and paid before anyone realized that error had been made. When a loss or claim is reported to an insurance company, the first task required of the insurer and its claims personnel is to confirm the existence of a policy. The task today is much simpler than it was when I was a young adjuster, when we had to pull out the actual underwriting file and review the daily report. Now coverage can be confirmed by computer, online, from anywhere in the world. If the insurer's computer system shows that a policy was in effect at the time the insured reported that a loss occurred, the first step of confirming coverage was completed. Next, if available, digitally, the entire policy must be accessed, including the declarations page and all policy wordings, all endorsements and modifications to the standard policy language. The claims person needs to have available a specimen of the policy as it would have been delivered to the insured, so they can be read, reviewed, and understood to enable the claims person to explain the available coverages to the persons insured. If the entire policy is not available electronically from the insurer's intraweb, it can then be recreated through the underwriting department or from an agent or broker. Once the policy is obtained and available for reviewing, sometimes by just asking the insured for his original, the claims person must read and understand the policy coverages and compare those to the wording of the policy to confirm that one of the policy coverages promises to indemnify the insured against the risk of loss of the type reported. For example, if the policy is a property policy that insures the insured against the risk of loss of a dwelling by fire, lightning, windstorm, or hail, and nothing more, and the insured reports a claim for damage caused by earthquake, the existence of a policy is confirmed, but the existence of coverage is not. If the policy is a liability policy, like a commercial general liability policy, and the insured reports that the mailman was bitten by the insured's pit bull terrier during the policy period, coverage is confirmed. However, if the policy contains an exclusion for losses caused by dog bites or pit bulls, coverage is confirmed with an exclusion that might be applicable. If the policy is a CGL, a commercial general liability policy, and the insured reports he was sued for slander by a business competitor during the policy period, coverage is confirmed, and there is available defense under the personal injury coverage part. If the policy is a national flood insurance policy in effect at the time that a water main breaks and floods the insured's house, Coverage is confirmed that the policy exists, and a determination must be made to determine if the loss falls within the terms and conditions of the policy. If a policy is a CGL, and the insured reports he was sued for intentionally punching a business competitor in the nose, coverage is confirmed that the policy was in effect, but questions must be answered to determine if there is evidence that indicates there was no intentional act, or that the insured was acting in self-defense or some other not intentional act. What these examples show is that the existence of a policy can be confirmed, and it can be easily confirmed that it was in existence at the time of the loss. What cannot be established from the loss notice and policy wording is whether the coverage applies to the loss that was reported. Once coverage is confirmed, then the claims person must read the policy, and the initial written contact with the insured should advise the insured of all benefits, coverage, time limits, or other provisions of an insurance policy issued by that insurer that may apply to the claim presented by the insured. The letter should include, as a bare minimum, information like the limits of liability of the policy, any deductibles or self-insured retentions, advice concerning any specific exclusions or conditions that apply to the facts established by the notice of loss, a written notice that a proof of loss is required within 60 days of the letter with an attached proof of loss form, a requirement for the production of necessary documents, a reservation of rights if called for because of a potential coverage problem like an exclusion that might apply, and any other information the insured needs. The claims person should also be prepared to supplement the initial letter whenever he learns of different facts or additional coverages available to the policyholder or the insured. Failure to properly and in writing advise the insured of the policy provisions, the requirements for documents, the problems with coverage based on the initial report of loss, can place a claims person inadvertently in violation of the state's Fair Claims Practices statutes and regulations, and expose the insurer to litigation for bad faith claims handling. Confirmation of coverage requires more than simply checking a computer. It requires an understanding of the policy wording, the facts of the loss, and the law of the jurisdiction to determine if coverage for a particular loss is available to the insured. Simply reading the loss notice, allegations in a lawsuit, and the policy is never enough. The first and foremost duty of a claims person is to confirm coverage. It is a beginning of claims handling and cannot, on its own, fulfill the obligations to confirm coverage before the adjustment begins. Claims Commandment 2. Thou shalt always conduct a thorough investigation. Investigation of a claim is a search for truth. It is an art form where facts are established. It has been defined by the state of California, for example, as follows, quote, investigation means all activities of an insurer or its claims agent related to the determination of coverage, liabilities, or nature and extent of loss or damage for which benefits are afforded by the insurance policy, obligations or duties under a bond, and other obligations or duties arising from an insurance policy or bond. This is California Code of Regulations 10 CFR 2695.2 paren K close paren, close quote. Notice provisions in insurance policies serve the important function of allowing the insurer the opportunity to make a timely and thorough investigation of the insured's claims. Courts will not subject an insurance company to a choice between liability under a bad faith failure to investigate theory for publication of a denial of coverage without an adequate investigation and liability for a constructive denial imposed after it has conducted a more thorough investigation that confirms an earlier determination of no coverage, on the theory of delay coupled with a wrongful intent. Rather, courts require that an insurer complete a thorough investigation before it makes a decision with regard to a claim for defense or indemnity under an insurance policy. Initial conclusions based on a bare reading of a lawsuit or initial investigative interview are not enough. Although an insurance company is entitled to make a thorough investigation to determine whether there is coverage under its policy, the company acts at its peril in refusing to defend its insured, in that if it is subsequently determined the company erroneously denied coverage, the company will be liable for damages for breach of its agreement under the policy and probably for additional tort damages. When an insurer denies or delays payment of policy benefits due to the existence of a genuine dispute with its insured as to the existence of coverage liability, the insurance company will not be liable in bad faith, even though it may be liable for breach of contract. One court gave the following instruction to a jury that is informative. Quote, "In determining whether or not an insurance company had a genuine dispute as to whether or not a loss was covered, you, the jury, may consider among the following. 1. Whether the insurance company was guilty of misrepresenting the nature of the investigation. 2. Whether the insurance company adjusters and investigators lied during their depositions or to the insured. 3. Whether the insurance company dishonestly selected its experts. 4. Whether the insurance company experts were unreasonable. And 5. Whether the insurance company failed to conduct a thorough investigation." Close quote. This is a case called McCoy versus Progressive West Insurance, a California Court of Appeal decision. An insurer has a duty to conduct an appropriate and careful investigation prior to making a decision on a claim. However, if after conducting a thorough investigation of the facts and circumstances giving rise to a claim, the insurer can reasonably conclude that the claim is debatable or questionable, there can be no bad faith, even though it refused to pay the claim incorrectly. The investigative interview is a structured conversation between a trained and experienced interviewer and a person who has no training in the interview or interview techniques. It is not an interrogation. It is not the stuff of spy films, police investigations, or prisoner of war camps. Interviews happen everywhere. Interviewing is performed by almost everyone. Since interviewing is an art, the most effective interview is one performed by someone with knowledge of the art. Insurance investigators are compelled to get the information they need by intelligence, wit, skill, and experience. They put people at ease. The skill of the professional insurance claims person causes the person being investigated to want to give information to the investigator. The most important skill of the professional is to cause the person being investigated to want to give to the professional the information he or she needs. To conduct a thorough investigation, the claims investigator should, at a minimum, ask and receive answers to the following and do the following. Read the loss notice and policy of insurance. If a lawsuit has been filed, read the lawsuit in conjunction with the policy wording. Interview the person insured, preferably in person. Obtain a recorded statement from the person insured concerning the facts of the loss. Interview and obtain a recorded statement from every independent witness. Interview and obtain a recorded statement from the claimant if suit has not been filed. If a suit has been filed, interview the attorney for the claimant about the factual basis for the suit and arrange for a statement with the claimant and the attorney. View the scene of the incident. Obtain all documents that have relevance to the claim, like the insured's copy of the policy, the police or fire report, if any, medical records, financial records, the application for insurance, contracts, if any, between the insured and the claimant, all other records that might be relevant to the claim and the policy, and consult with necessary experts like investigative engineers, coverage counsel, defense counsel, medical professionals, architects, forensic accountants, certified fraud examiners if fraud is suspected, all other experts that might be relevant to the claim and the policy. If it appears that there is coverage for the claim loss, advise the insured of the insurer's decision. If it appears there is no coverage, consult with management to review the facts gathered by the thorough investigation before a decision is made. Failure to conduct a thorough investigation is a breach of the promises made by the policy of insurance to provide defense and/or indemnity to the person insured. Failure can also result in the insurer being sued for the tort of bad faith and with tort and punitive damages. Insurers must, to comply with current law, conduct a detailed investigation of the facts of the loss and policy acquisition, a determination of the expectations of the insured and the insurer at the time the policy was acquired, a determination of the purposes for which the policy was acquired, an examination of all communications between the insurer and the insured or their representatives. If the investigation is not conducted, the insurer will invariably face suit for the tort of bad faith. The thorough investigation requirement first enunciated by the California Supreme Court in Egan v. Mutual of Omaha Insurance Company is essential when attempting to interpret a disputed policy of insurance. In Egan, the Supreme Court concluded that an insurer cannot reasonably and in good faith deny payments to its insured without thoroughly investigating the foundation for its denial. This ends the first two of the 15 claims commandments that I will publish as time goes by. The commandments also exist in several articles I have written and are somewhere in my magnum opus, Zelma on Insurance Claims, a 10-volume work available on Amazon.com or through my website, www.zelma.com, by clicking on the Insurance Claims Library link.